Hello, and thanks for tuning in for this important SCR webinar. Joining us today is R. Alexander Pate II. Alex is staff counsel with the South Carolina Human Affairs Commission. Before starting with the SCHAC, he was an attorney for the South Carolina Department of Consumer Affairs. Alex received his JD degree from the University of South Carolina and attended the University of South Carolina as an undergraduate. In addition to his interest in public service work, he enjoys cooking, whitewater rafting, and spending time with his two Siberian Huskies. Thanks for joining us today, Alex, and with that, I'm going to turn it over to you.
Thank you. Good afternoon. Like Mike said, I'm a staff counsel with the South Carolina Human Affairs Commission, specializing in fair housing. Today we're going to do an agency overview, description of our investigation process, and then move on to the main focus, which is going to be disability, specifically accommodation and modifications. And then we'll save some time for questions at the end. So if you end up having a question, type it into the chat. Mike will compile those, and then we'll look over those towards the end there. So no presentation by an attorney is complete without a disclaimer. The content I'm presenting today is provided for information purposes. I'm speaking on behalf of myself. I'm representing the agency here, but if there's any mistakes, those are solely mine. The takeaway from the disclaimer is that none of this is legal advice and does not create an attorney-client relationship. If you do have follow-up questions, though, after the presentation's over, I'll provide my information at the end, and you can certainly contact me directly or the agency for any additional questions you have. And with that, we'll go ahead and get started. So the mission of the agency is to prevent and eliminate unlawful discrimination in employment, housing, and public accommodations. We're going to be focusing on housing today, but the bases that are identified for protection from discrimination in the housing context are race, color, national origin, religion, sex, familial status, and disability. And we're going to be focusing on disability later, but again, if you ever have any questions on any of the other bases or fair housing in general, you can certainly contact us about those. So our agency is the state level equivalent of the EEOC in employment and the state level equivalent of HUD or DOJ in the fair housing context. And we're governed by the South Carolina Human Affairs Law and the South Carolina Fair Housing Law. Both of those laws are substantially equivalent to their federal counterparts. And so a lot of the times whenever we're analyzing a situation, it's going to be done through the lens of federal case law. There's a case out of South Carolina that describes our statutes as having inherited the judicial gloss associated with the federal laws. So if you hear me reference a federal case, that's why that is applicable. So moving on to the investigative process, whenever in this case a tenant or somebody who's involved in some way in the housing process feels that they've been discriminated against in some fashion, they'll file a complaint with our agency. So that'll initially be brought in through the intake process. They'll review the allegations on their face to make sure that the housing provider meets the jurisdictional requirements for number of houses or the type of units being offered. There'll be a potential for mediation at that point. If there's a impasse at mediation, that'll proceed on over to the investigations division. So the investigator will send out the complaint to the housing provider and try to get a position statement from them, which is basically a housing provider's opportunity to say, okay, that was the tenant was saying XYZ happened, but here's what really happened, or here's our version of what happened. The investigator has the authority to request documents, copies of leases, policies, other housing records, in order to try to arrive at a determination. Once the investigation is complete, the investigator will present their determination to the head of our Fair Housing Division for his review. Then that'll be presented to the attorney for review through the legal process, and then finally the finding will be issued by the agency head, our commissioner. Once that's happened, if the agency finding is that there was no reasonable cause to believe that discrimination occurred, that'll result in a dismissal. The important thing to note here is that even if there's a dismissal from our agency, that doesn't necessarily mean that the discrimination didn't occur. It may just be that we didn't have the appropriate documents or we couldn't arrive at that point. But a suit can still be filed in civil court by the charging party or the complaining party to pursue that outside of our agency. On the other hand, if the finding of the investigator approved by the commissioner determines that there is cause to believe that discrimination has occurred, we'll move on to a conciliation effort. I guess backing up for 1 second here, if there is an appeal of the SHAC finding, the commissioner or a request for reconsideration can be submitted, or a party may appeal to HUD to have them review the case if they think that there's been an error there. So once a reasonable cause finding has been issued, there's a conciliation effort. That can take the form of informal conciliation or mediation. The agency has a mediator on staff who is not involved at any point in the investigation or the determination stage, and is a professional mediator. That's what he does, 5 days a week with our agency. If the conciliation efforts are successful, then the complaint's closed at that point, and whatever the terms of the agreement are going to be, how that issue has been resolved. On the other hand, if a conciliation is unsuccessful, there are kind of three options that exist there. It's CP on the slide here, a charging party, whoever it is that filed the complaint with us, can file a lawsuit privately. The charging party or the respondent, the housing provider, can elect for a public hearing, or either of the parties can elect to have the agency file a lawsuit on behalf of the charging party, in which case that'd be filed in the circuit court where the discrimination occurred. If it goes to a public hearing, that hearing would be conducted before the board, or a three-member panel of the Board of Commissioners that govern the agency. That's done in accordance with the Administrative Procedures Act, and it's very similar to a court setting where an agent of the agency will present all the information. There'll be witnesses called, and the respondent housing provider would have an opportunity to be represented by counsel if they wished, or present evidence themselves. At the conclusion of that hearing, a decision is going to be issued, either a reasonable cause decision, in which case the panel would issue an order, usually containing some provision for injunctive relief, potentially damages, or on the other hand, a no reasonable cause decision, in which case an order is still issued, but the order will dismiss the complaint as being unfounded or no reasonable cause. On the other hand, if either of the parties elects to have the complaint resolved in circuit court, the first step would be the agency filing the lawsuit, and then in all of the counties now, there's a court-mandated mediation, and so the mandatory mediation would take place. The costs of that are usually split between the parties, and it's a third-party mediator, either selected by the parties or ordered by the court. A mediation, just like the conciliation, can result in a settlement, in which case the case is dismissed pursuant to the terms of the agreement. Or if there's no settlement agreement, then the mediation arrives at an impasse, the complaint would proceed to a hearing before whatever circuit court the complaint is filed in. So that's kind of the overview for the investigative process. We're going to move on to a focus on disability as one of the protected bases. Some background on disability as a category of complaint. For the past, I believe it's 2017 now, so for the past 8 years, disability as a category has been rising, and starting in 2011, I believe, it's now accounts for over half of all complaints filed with HUD. And of the complaints that are filed alleging discrimination with disability as a protected basis, over half of those are for failure to make reasonable accommodations. Now, a lot of times there'll be multiple issues in a complaint, so a single complaint might address multiple issues. There might be design defect issue as well as a reasonable accommodation issue. But the point here is that this is first of all, a growing category of complaints, and also accommodations as a growing percentage of those complaints received. So one of the first things you want to look at is who is considered disabled per the Fair Housing Act or Fair Housing Law. And there's generally three categories of people that are disabled as defined by the statute. The first is a person who has a physical or mental impairment, which substantially limits one or more of the person's major life activities. And we'll get to major life activities here in a second. The second category is going to be somebody who has a record of having such an impairment. And then the third is going to be somebody who's regarded as having an impairment. Now that category is a little rarer than the other two, but it can include somebody who wouldn't actually be disabled definitionally, except they're viewed as having a disability. And if somebody acts on that perception of them as being disabled, they would be protected by the Act. So a physical or mental impairment is going to include many things. The categories have been kind of expanding as we have a better understanding of what constitutes a disability, as well as better tools for diagnosing disabilities. But it's definitely going to include visual or hearing impairments, mobility impairments, diagnosed mental illnesses, emotional illnesses, intellectual disabilities. This next category, alcoholism and past substance abuse. One of the, that's kind of a tricky area here, where a lot of housing providers will have restrictions on drug use, and will have provisions prohibiting prospective tenants from applying for housing based on past substance abuse, and that can run afoul of the disability protections of the Fair Housing Act. So that's one of the areas you want to be careful on when you're crafting your policies. Disability also includes chronic diseases, and we're seeing an increase in claims regarding or complaints regarding chronic disease as a disability category. Part of that is just a demographic issue where you have baby boomers continuing to age into a demographic where there's an increase in the numbers and severity of chronic diseases. And then finally, disability can be temporary. There's some disabilities that might impair mobility that are only on a temporary basis, and so there's some kind of a gray area there regarding non-chronic temporary disabilities. So we talked earlier about major life activities as being, kind of definitionally part of what qualifies as a disability. So major life activities, this is not a comprehensive list, but generally, these are going to be some of the very obvious ones that you'll want to consider. Anything that deals with one of your senses is likely to seeing and hearing, maybe not smelling, but that could be. Mobility-related issues, breathing issues, performing manual tasks and caring for oneself are two of the, again, growing areas of disability. This especially in the context of like a live-in caretaker or aide, where that's usually tied to that. But speaking and thinking are also major life activities. And there's other items that could be added to this list. This is not an exhaustive list, but really it comes down to what a medical professional would identify as some sort of impact on someone's quality of life or their capacity to enjoy the premises. Which leads us into the actual, I guess, the focus of the presentation today: reasonable accommodations and reasonable modifications. So the Fair Housing Act requires that a landlord may not unreasonably refuse to provide a reasonable accommodation of a rule, policy, or procedure to address the needs of a person with a disability. Further, a landlord may not unreasonably deny permission to a tenant to make a modification of the premises to address the needs of a person with a disability. So I highlighted or italicized some of the terms here that we're going to be looking at. Those are kind of the key phrases that are that have further expanded definitions or understandings as we progress forward. So the first one is going to be what is reasonable. First of all, it's economically and architecturally feasible. It doesn't alter the fundamental nature of the program, and each request must be considered on a case-by-case basis. So the point here is that a request for an elevator that leads directly to their room, or a moving sidewalk or something to that effect is probably not going to be economically or architecturally feasible. Whereas something like grab bars in a shower, or waiving a pet deposit for a service animal would certainly be on the feasible side of things. The alteration to the fundamental nature of the program is another kind of a relatively high bar for a housing provider to assert. And unless the requested modification or accommodation is just vastly outside the nature of the services provided by the housing provider, that's unlikely to be one that can be asserted as a defense to granting an accommodation request. An example of that would be if somebody requested to move to a different unit and wanted the housing provider to provide moving services, unless that was something that they did in other situations, that would probably be a fundamental alteration to the nature of the services they provide. Most housing providers don't provide moving services. So, on the case-by-case basis, the big takeaway here, and we'll talk a little bit more about that later, is that once a request has been made, the housing provider has an affirmative obligation to engage in what's called an interactive dialogue. They're required to talk to the person making the request and try to figure out a solution that is going to satisfy both parties there. Now, the housing provider has certain requirements legally that they need to adhere to, and the tenant has certain responsibilities legally that they need to attend to as well. But there is a requirement that you talk to your tenant when they're making a request to try to figure out a reasonable accommodation. So whenever a request is made, one of the questions we often get asked is, what can a housing provider ask for? So whenever the need is obvious and impairment, or obvious and apparent, so somebody who's in a wheelchair, there's no need to ask for the documentation there. If it's not readily apparent, then you're allowed to ask for documentation of the individual's disability-related need for the request. Now, I have here in bold letters, not the entire medical history. There's no requirement that they actually explicitly state even what the disability is, just the nature of the disability, and why it's related to the requested accommodation. The sources for the documentation can include a doctor's note, a note from a therapist, peer support groups, non-medical service agencies, or even the individual themselves. Now, you're not required to automatically accept somebody's statement that, oh yeah, I definitely need this dog, but if they do have a readily apparent disability and the nexus between the requested accommodation and the disability are apparent, it may be the case that you don't even need to seek that additional documentation. So the four-part test that is used to determine reasonableness is, step one, does the applicant tenant have a disability? And again, that if it's readily apparent, there's no need for documentation on that front. Is there step two is there a nexus between the disability and the problem? And sometimes that'll be readily apparent. A seeing eye dog for somebody who's visually impaired, you don't need any additional information on that front. On the other hand, if it's a mental disability, you may want a doctor or therapist note, just explaining so you understand what the connection is between the disability and the requested accommodation. The third step is, will the accommodation or modification fix the problem? Somebody who is wheelchair bound and is asking for a door to be expanded. Okay, well that's very clearly going to fix whatever the issue they need addressed. Whereas requesting an emotional support animal for a non-emotional support basis might be a little more nebulous and harder to meet that requirement. And then the final step or final part of that question is it an undue burden on the housing provider? The answer to that in an accommodation context is mostly going to be no. And we'll talk some more about that in a little bit, but the step there is if it's an administrative or financial burden, and the court cases that have addressed that have found that to be a relatively high bar. It really has to be an actual hardship for the housing provider to meet that standard there. So backing up to the interactive process, said before, the landlord has an affirmative duty to participate, and the tenant also has a duty to show that the accommodation is necessary and reasonable. So the interactive process, and there's no hard and fast rule for what exactly meets that requirement, but at the very least, receiving their request and addressing their request is going to be required. You'd be surprised at the number of complaints we receive where somebody ends up getting evicted for requesting their accommodation in regards to a service animal, and the housing provider is just like, oh yeah, I received the request, I just didn't think I had to respond to it. So at the very least, you have to respond to the request. But ideally, there would be some back and forth where the tenant would demonstrate the necessariness and reasonableness of the accommodation request, and then the landlord would work with them on trying to best meet their needs. So getting more specifically into reasonable accommodation, the reasonable accommodation is generally going to be a change in the rules, policies, practices, or services of a housing provider so that a person with a disability will have an equal opportunity to use and enjoy a dwelling unit or common space. That's usually not going to require an expenditure of money on the part of a housing provider. There have been some court cases that have shown where that may include incidental costs. I guess the most common example is restriping a parking lot is generally a reasonable accommodation, but may require some expenditure or some outlay on the part of a housing provider. Just definitionally, and this gets into that interactive process, a housing provider should do everything she can to assist, but is not required to make changes that would fundamentally alter the program or create an undue financial or administrative burden. So again, the big takeaway here is that if the housing provider or the management company or whoever it is that receives this accommodation request, if the request is for them to actively do something that they don't currently do, that can be a fundamental alteration, and they may be able to reject the request in that regard. On the other hand, going back to the restriping a parking lot example, a management company may not be in the business of restriping a parking lot, but they're certainly responsible for that. That's something that they would pay to do whenever it needed to be done on a 10-year basis or however often that happens. So that would not be a fundamental alteration of their program to require them to do that as part of a accommodation request. The final broad point on reasonable accommodations is that those can be requested at any stage of the housing process. So somebody who hasn't applied to a dwelling unit yet can make a request. Somebody who is actively engaged in or is a current tenant can make a request. Or if an eviction is imminent, they could make a request at that point. Again, if the eviction is related somehow to their accommodation request. So the next slide is just and this will be relevant again here in a couple of moments when we talk about emotional support animals. But Anderson v. City of Blue Ash involved a child with multiple disabilities who had a doctor prescribed for them equine therapy, which was have a miniature horse reside in their backyard for walk and play and exercise for the therapeutic benefit. The city rejected that, and the court ultimately said that that was going to that was a reasonable accommodation to allow that They provided some guidelines for how to address, some of the particular aspects of, of animals in general and a horse in particular, but said that a horse was not, per se, unavailable as an emotional support animal under the Fair Housing Act. So stepping away from reasonable accommodations for a moment, we're going to move on to reasonable modifications. A reasonable modification is going to be a structural modification made to allow persons with disabilities the full enjoyment of the housing and related facilities. The big difference, and again, not a bright line rule, but the big difference between an accommodation and a modification is usually there's going to be some sort of expense associated with the modification, and the resident or tenant will have to bear the cost of that modification. So in the reasonable modification context, there's a difference between an interior versus an exterior modification. An exterior modification would be something like a wheelchair accessible ramp, and generally a tenant is not going to be required to remove that whenever they leave. Exterior modifications could also include things like making common amenities available, so altering curb cuts to access a mailbox, or making a pool accessible. Now, a note here, we talked earlier that saying modifications were generally going to be at a tenant's expense. The one kind of broad exception to that is going to be buildings that were built or set for first occupancy after 1991. Whenever those were not designed or constructed in compliance with the accessibility requirements of the Fair Housing Amendments Act, courts have found that those modifications may be required to be done at the housing provider's expense. So that's one of the things that we advise people to look into, especially HOAs or management groups who have inherited or purchased property that but they were not the original constructors or designers, is to take a look at those, make sure that they're in compliance with the FHA, and if they're not, just know that if a request does come in, that they'll ultimately end up bearing the cost of making those accessible. On the other hand, modifications that are made to the interior of a house are generally generally a housing provider may require the tenant to remove or restore those. Some examples of those would be lowering the sinks and the cabinetry in a house or a kitchen, installing grab bars and showers, or widening the doorways to allow accessible entry. Now, I have a little star here on the last one. One of the things that I guess the decision calculus in determining whether or not a landlord or owner can require a tenant to restore the interior is whether or not it's, first of all, if it's reasonable to do so, and then second, if its presence affects the provider or subsequent tenant's use or enjoyment of the premises. And so courts have generally found that whenever a doorway has been widened to make it accessible, that's not going to negatively impact the use or enjoyment of the premises. And so a housing provider cannot require a tenant to restore doorways, whereas lowering all the sinks and cabinetry could limit the potential use of that unit. And so those might be, or that would be an example of something where a tenant or a landlord could ask a tenant to restore those at the end of their tenancy. So moving on to kind of the hottest topic in disability accommodation request here is going to be animals. And there's kind of three broad categories of animals, excluding the Muppet, that we look at in fair housing. The first category of animals are going to be pets, and those are exactly the kind of animals we're all familiar with. If an animal is a pet, then the housing provider can set any sort of restrictions they would like to. That's ultimately going to be a pure contract issue. There's no fair housing implications as it pertains specifically to pets. However, A service animal is definitionally not a pet. The definition for service animal is found in the Americans with Disabilities Act, or ADA. And a service animal is going to be a dog that is trained to do work or perform tasks for the benefit of an individual with a disability. And so the big takeaway here is there's there's definitionally a difference between a pet and a service animal. And the service animal, the big thing there is they're going to have special training to perform tasks for an individual with a disability. Just some, again, a non-exhaustive list of services a service animal could provide. And, that literally, an animal can be trained to do just about anything or, provide any sort of service. So this, again, is a non-exhaustive list, but just some sort of broad examples of what sort of things a service animal could do. So we get a lot of questions about what sort of inquiries a housing provider can ask about a service animal. And it's really, there's two questions that can be asked. The first one is the service animal required because of a disability? And what work or task is the animal trained to perform? You'll notice that those questions do not include the nature of the disability or the extent of the disability or what the disability is or any sort of medical records. The real extent here is just that, is the animal required? And then the second question, you can't ask the owner to demonstrate the service animal's task. You can't have the or can't require that the service animal demonstrate its capacity to perform those tasks. Some additional issues that pop up in the context of a service animal. There are some instances in which a service animal can be excluded if it's not controlled or if it's not housebroken. Under those circumstances, a service animal could be prevented or could be denied. If it says entity is not, or the housing provider is not going to be responsible for the care or supervision, so that's going to fall to either the owner or somebody associated with the owner. There is no service animal license or documentation required. There are many service animals that do have some sort of licensing from a third-party entity, but there's no official, at least in South Carolina, no official government entity that registers or licenses those, and that can't be made as a prerequisite to granting that accommodation requests. Finally, no additional deposits can be required. If there is, if your housing service does allow pets but requires a pet deposit, that pet deposit cannot be assessed to somebody who has a service animal. If they have additional pets, or animals that are pets as opposed to service animals, the deposit can be assessed to them. But for a tenant's service animal, you can't request an additional deposit. Now, the flip side of that, or is on the tail end, whenever a tenant is leaving, they're still responsible for any damage beyond the usual wear and tear on a housing unit. So if the housing provider, on a general basis, has provisions for assessing some sort of monetary penalty or repair costs at the end of the tenancy, those same policies and procedures can apply to a housing unit with a tenant who has a service animal. Now, you want to be careful that you're not only, if it turns out that the application of that policy only applies to tenants with service animals, that's going to be problematic. But just make sure that you're applying the policy evenly, and that should not be an issue. So said there were three categories of animals we were going to look at: pets, service animals. The third category is assistance animals, and that terminology is kind of broad, can apply to several different categories, types of animals. Emotional support or therapy animals are also fall into that same category. And just generally, assistance animal is going to be one that provides support, assistance, or service. Some of them are trained, but they may also be untrained. And then a assistance animal is not just a dog. It can be just about any sort of animal you can imagine. Some examples that have popped up at different times are cats, birds, guinea pigs, ferrets, a miniature horse, or a monkey. So I guess the big takeaway here on the type of animal it can be is just about anything. So an assistance animal must be allowed if an individual has a disability, is defined by the FHA, and there's a relationship between the individual's disability and the assistance provided by the animal, or a nexus between the disability and the assistance provided. The process for an assistance animal is similar to any other accommodation request. First of all, an oral request is enough. You can't require that they use your written application form. On the other hand, whenever I'm talking to somebody who is a tenant and they're having some sort of issue with a modification or accommodation request, I always tell them to put it in writing. That just works better for everyone involved. But an oral request is sufficient, and you can't require them to use your particular form. Now, on the other hand, when you're responding to a tenant, I would recommend, just as general practice, to respond in writing with everything. That helps protect you on the back end, but also just helps to make things clear for everyone involved whenever there's a clearly defined paper trail there. Whatever process is in place, which again is not to say that you can't have a written process that you ask them to use, but you can't require that they use that particular one. But whatever the process is, it should be easy for somebody, and it should be quick. There should be some sort of policy or procedure in place to make sure that responses are timely. A undue delay in responding to a request can be deemed a denial and could put you in hot water as far as a violation of the Fair Housing Act. If the disability and the need for the animal are observable or known, then there's no verification needed. Again, that would come back to if somebody had a very obvious or an apparent disability, and whatever animal they had had a demonstrated service or assistance to them, it may not be the case that you actually need verification at that point. Excuse me. On the other hand, if the disability is not apparent or the need for the animal is not readily known, you could ask for verification from the tenant. And there's many ways that can be verified. Note from a doctor or medical or social service professional, peer support group, a non-medical service agency, or a reliable third party, or potentially even the individual himself. Now here it has some examples of when the individual might be able to provide that verification. If somebody's on Social Security disability insurance, a receipt for rehabilitation services, or even just a credible statement, that may be sufficient to meet the requirements that they demonstrate or verify the disability or the need. One thing, and actually this is as good a time as any to talk about it. One of the things that we've been getting a lot of questions about, and actually have investigated previously, are these kind of third-party websites where you go in there. Some of them deem themselves as support animal registries or assistance animal registries. And first, we already know, saw that a couple slides ago, that there's no registration required for service animals, and there's certainly none required for emotional support animals. But the big issue here is people going to these websites, filling out an online medical questionnaire, and printing out a note from this doctor in Timbuktu or wherever, saying that they have a need for emotional support animal. That's might reflect a moral disability, but not an actual disability. And so one of the questions we get from providers, housing providers, is what can we do if we suspect that? And again, this gets into kind of a gray area where you don't want to unnecessarily delay or harass somebody with an actual disability. But on the other hand, if you get this note and it's not on a doctor's letterhead, or it just looks funny. I mean, we've seen during some of our investigations where we'll actually get these notes submitted to us, which are literally just scanned from or printed off from a website. And so we had one instance where somebody actually signed a local doctor's signature onto their own note. The doctor, whenever we contacted them, had never heard of this person, was not seeing them, that sort of thing. So you can, whenever they're providing or verifying their disability or need, the takeaway there is that it needs to be a credible verification. If it's a local doctor, then that's probably going to be credible if it's on their letterhead, has a signature. If it's an out-of-state doctor or there's not on a letterhead, that doesn't necessarily mean that it's invalid, but it could be the case that there are people out there who are trying to game the system, and we're cognizant of that. We're not here to tell housing providers they can't ask any follow-up questions, but there needs to be something on the face of the statement that is making you question its authenticity. If you make it a policy to, every single time you get a doctor's note to follow up on that and ask for additional things, at that point you're kind of veering towards delay or denial of requests. So again, it's kind of a balancing act, and there's no hard and fast rule. But whenever you have a document that looks inauthentic, you can ask some follow-up questions or seek to verify the authenticity of the document. And I'm sure we'll get some questions on that at the end, but some things that a housing provider may not do, you can't require details about the history, nature, or extent of the disability. You can't require access to medical records, and you can't require detailed information about the animal. Once you have a doctor's note or some sort of credible verification of the nature of the disability and the extent of the need for the animal, there's really no additional inquiry necessary there. The other big thing we run into is, and this can actually even happen at outside of the housing provider, a city ordinance or a county ordinance. A housing provider can't impose breed, weight, or size limitations on a service animal or a support animal. The big one you see are pit bulls, although there's German shepherds have been added to some of those lists. But the breed, weight, and size limitations cannot be applied to service animals or support animals. You can apply those to pets, but again, just categorically, they do not apply to the other two types. And just like service animals, you can't require a fee, deposit, insurance, hold harmless agreement, vet records, special conditions on the support animal or assistance animal. Now a county may have, or a town may have vet requirements. But those are issues that would be dealt with by the city or county. That's not a housing provider's duty to impose those or to follow up on those. And then the final thing, and this applies to again service animals or support animals, is there shouldn't be any restrictions on indoor or outdoor access to any areas of the housing unit or to the public and common use areas associated with the housing. There can, and we'll get to some of the bases for denying a request, but generally speaking, any area that a resident can go to, their service or support animal should have access to as well. So, again, we talked earlier about breed restrictions, and the safety of an animal is one of the bases for a housing provider to deny a request as unreasonable. But that needs to be based on an individualized assessment of the specific animal. They would need to be able to, a housing provider would need to show that a specific animal poses a direct threat. So if there's evidence of a biting incident or something to that effect, then that could be the basis for rejecting a request. but it can't be based on, again, the type or breed of animal. It needs to be done on an individual basis. I was not too surprised when I saw this, but there's some court cases regarding exotic animals. Somebody was trying to claim that their alligator was an ESA, and the court ran through the analysis there, but said that it would be reasonable for the housing provider to deny that accommodation based on an individualized assessment of that particular animal. And again, that's there's some city and state ordinances that address exotic animals as pets. Those are, again, not going to be directly applicable, but could provide some guidance for what sort of animals might not or might pose a threat. But again, that needs to be done on an individualized basis, as opposed to, say, a categorical barring of all, tigers or whatever the case may be. Another basis for denial is undue financial or administrative burden, and we talked about that a little bit earlier. But that's again an exceptionally high standard to meet, and is generally not going to be applicable, especially for accommodation requests where the housing provider is not having to do anything except not apply one of their rules or to change the standards of their policies. It's very difficult to show that's going to have a financial or administrative burden beyond the beyond the acceptable parameters there. There's a series of cases addressing I believe it is Social Security disability payments, and for however it was set up at this particular housing complex, rent was due X day of the month. Social Security payments came in 4 days after that due date, and the court determined that it was not undue administrative burden to allow that tenant to make their payments 4 days after when everybody else was doing theirs. So. And then the final common basis for denial of fundamental alteration. Again, that's a very high standard, and would really only be applicable if it was something just wholly outside the bailiwick of the housing provider or management group or whatever entity the request has been addressed to. For some more information on any of those topics, Housing and Urban Development has some guidance that they publish pretty regularly. They have a joint statement on reasonable accommodations, and then some guidance on service animals and assistance animals. Those are available at those websites. And then information on filing fair housing complaints can be found at the HUD website. Some of that information can also be found at our website for the South Carolina Human Affairs Commission. That's our contact information there. And then my contact information down there, if you end up having a particular question, a lot of times we can address that. And we always tell people that it's better to call and get advice and some scolding from us than to wait for a complaint to be filed and then get advice, scolding, and a fine on top of that. So definitely, if you have a question or want to reach out to us, welcome to do that. The agency also provides training for organizations, and we have in employment, housing, or if there's a particular issue you want us to address, we can do that as well. At this point, I think Mike has compiled any questions we might have. Okay, so no questions as of right now. But like I said, if you end up having any questions, viewing this later on, even if it's a couple years down the line, certainly feel free to contact our agency, and we'll be able to address those questions. Now, the agency can issue official opinions. That's a slightly more complicated process, other than just calling me and asking me for my quick take on something. And that process, again, is just addressed through our website. Those opinions would be anonymized and then placed on our website to act as guidance for other entities in addressing similar issues. But just want to thank you all for attending, and hope you have a great day.